If we could, if we make an announcement outside, I did tell people that they could come back in. If they're here in support of this case or interested in this case, tell them they can't come back in the courtroom before we get started. I just asked everyone that was not a defendant to step out so we could get who coming out. But I did let everyone know that would be allowed to be back. Thank you. All right. We're going to go ahead and get started. This is the state of Georgia versus Sarah Grace Patrick. This is our calendar call for the trial week of 8/3. It's my understanding that the defense has a short motion that they'd like to be heard. And then state, I believe, has also had a response. So defense, whenever you're ready.
Thank you, Your Honor. And as the court said, we filed a motion, so I will be brief on, I won't go into the case law as much because I know the court's already seen it. So, and again, for the record, I am, there you go. And for the record, my name is Shawn Hoover. I have recently joined, or I am the attorney for Ms. Patrick moving forward. Latoya Williams was the attorney. She no longer works with the Public Defender's Office, so I will be moving forward. Carolyn.
Now, I know that you paused and said recently, you overtook this case in February.
February, that's correct. For me, it's recent. There's been a number of trials since then now. So I've been on the case since February, Your Honor, and we're asking for a continuance today regarding Ms. Patrick's case. I know the court has already read the case law involved. Just to put a couple of highlights on the record. For starters, Your Honor, once I took over the case, I put an entirely new team on Ms. Patrick's case. With that said, I got the case, there was a lot of discovery involved, started to go through the discovery while I was trying other cases. Once I realized there were certain issues that hadn't been addressed when Ms. Williams represented Ms. Patrick, I started to create a team or bring a team in that could address those particular issues. At the beginning, I thought it was just a chain of custody issue, and it turned into a lot more than that. To give you an idea or a little more of an understanding, I brought in Mary Dayton, who is an attorney with the Public Defender Office. I worked with her when I was in the Capitol Office. She does a lot, has done a lot with juvenile clients, especially juvenile clients dealing with capital cases and dealing with forensics. What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the Sheriff's Office, Police Department, and just evidence in general. With that said, we brought in also a mitigation investigator, Olivia, who's at the table with us as well, who also deals with capital cases, also deals with juvenile cases, but also deals with the mitigation aspect of it. Once Ms. Dayton and Olivia came in, we found out that based off of current case law, not only with the United States, but also in Georgia, certain issues weren't addressed when Ms. Williams had the case and Ms. Williams announced ready. Mainly because of the age of Ms. Patrick when the shootings actually occurred. Because Ms. Patrick was a juvenile at the time, case law is a little different when it comes to, for one example, sentencing in regards to how and when a juvenile can be sentenced to life without possibility of parole, death penalty, or life with possibility of parole. Because of those issues, I believe it was about 2 weeks ago, I believe Olivia just said that we got the DFCS information around June 30th, which literally wasn't that long ago. Yes, Ms. Williams had an expert that to be nice, did some work on the case, but the expert didn't have Ms. Patrick's, and the expert I'm talking about, Dr. Schaefer, didn't have Ms. Patrick's defects records when he did his evaluation, when he spoke to Ms. Patrick and family members, when he came to his ultimate conclusion. Now that we have the defects records, that has opened up, lack of a better term, a whole other can of worms in regards to not only sentencing because of Ms. Patrick's age, but also our theory moving forward, especially crossing certain officers and certain witnesses based off of the evidence that we did receive from the state. So with that said, we're asking for a continuance for multiple reasons. The first one will be because now that we actually have a team in place that can actually address the issues facing Ms. Patrick because of her age at the time of the shooting and because of all of the background history that Ms. Williams, she just didn't know about because she didn't have it. Literally, we sent you the order and you got the information to us as quickly as possible. But we're talking about over 10 years worth of information that now we have to go through not only for sentencing, but to combat certain things that I believe witnesses and especially officers are going to say on the stand in regards to their investigation. So we're asking for a continuance for that reason because we just need more time to go through all of that. Again, the case law, like I know the court's aware of the case law. The case law, not specifically, the case law points towards it's a sentencing issue, which it is, and we need more time for that. However, without going into more detail, there were certain statements made and certain reports that were written from the lead investigator and other officers, which tells me now that those defects records, the mitigation aspect of this case that we thought was something that we had, that wasn't as important in the trial, well, now it is. Because based off of what we've read and based off of what we received, it will be an issue in this case, especially with the lead investigator. So the first point we're asking for a continuance is because we now have the team put in place to address the issues specifically based on the mitigation aspect of this case, which was not addressed before. Dr. Schaefer had an evaluation that the state has and the court has, but he did not have the information that we have. And based off of that information, more needs to be done so that I can adequately protect Ms. Patrick's interests moving forward. Furthermore, we're asking for a continuance, Your Honor, based off of evidence that we believe is still outstanding. And when I say that, again, when Ms. Williams had the case, the state of Ms. Williams announced ready for trial. And I understand based off of the information that the parties had at that time, they believed they were ready. However, once I took over the case again, I thought this was just a chain of custody issue, and it turned into something a lot bigger. And to give the court an idea without going into too much detail about our theory, since I've taken over the case, I've actually been able to delve or dive deep into it. There are issues with what officers did in this case. There are issues with the Georgia Bureau of Investigations in this case, and we have started to get more information, more evidence from the Georgia Bureau of Investigations and from law enforcement. With that said, the state and I met on Friday in person to go over the physical evidence in the case, and we talked about that as well. And the state is helping us get more information. And to be clear, this is not an issue that like the DA was hiding information. This was more of, I saw an issue that I believe Ms. Williams just didn't see, and it snowballed into something a lot bigger than just a chain of custody issue. So now we are still trying to get information from Georgia Bureau of Investigation to fully understand the forensics in this case, to fully understand the chain of custody issue in this case, to fully understand the procedures in this case. And we are literally still requesting information from GBI that's still coming in. And now we've actually asked the DA to help us out on that because this is information they need as well. So this isn't something that's like, well, we knew about this earlier. This literally, again, started out as a chain of custody issue, And it has snowballed into something bigger to where we're going, and this deals with possible 702 downright issues moving forward. We're literally dealing with forensic evidence. We're literally dealing with chain of custody issues, proper procedure issues, not only through local law enforcement, but through the Georgia Bureau of Investigation. So we're asking for a continuance on that as well, because there's still information coming in. And finally, Your Honor, and again, this is not me saying the state withheld anything, because I honestly believe the state didn't know about this as well. But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports. This officer is on the witness list. But from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the report. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong. My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch turned into, it went to another person that had the gun, and the officer tested the gun, and then gave it back to the other person. We had no idea these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion. And again, Ms. Williams and the state announced ready for trial for January. The state didn't know about this. We are now in a position to where I honestly don't know, was this one road officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the two people, well, it is more than two people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information that we have uncovered since I've taken over the case and I brought my team on, that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this is not the DA's office that held any of this information. This was now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem. And as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law, courts already the case law, so I'm not going to delve into that, but we are in the position now that I understand this trial was set, or this case was set to go to trial. And I understand that Ms. Patrick has been in jail this entire time. She and I have had this difficult conversation, but I'm in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we are asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the lead investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief, but now we know GBI evidence that there's still more coming in, still more information coming in, forensic evidence, there's still more coming in. We will be having 702 downward hearings. We have to on specific information, what will be admitted, what won't be admitted, who will be an expert, There's a chain of custody issue, and again, now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about, there's new, again, forensic evidence we need to talk about, there's new contact information we need to talk about, and this is not from the state, this is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With all of that said, Your Honor, due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole, as a defense attorney, I need more time to uncover or to just delve deeper into all of this new information that we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this because another officer popped up with new information we didn't know about before. Like, this is not I'm grasping at straws. There's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
Thank you. State, do you have a response?
Thank you, Judge.
State, you'll approach and give your response.
Thank you. I do want to touch on a couple of things. First, in basically the order that defense counsel went through them. He said that there is a new team that they put together specifically for the mitigation or issue, specifically regarding the DFCS documentation. I'm going to break that down a little bit. First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're now asking to change their expert. If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case. And they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that. It was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the DFCS records that we brought up, we got those DFCS records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
So the state's position is that the vast majority of the DFCS records that were turned over, say, about 3 weeks ago, are duplicates that have already been available to everyone.
Yes, either the documents themselves or the information contained therein. They are information that was out there long in advance, things going back to the history of the defendant in relation to her interactions with DFCS.
Thank you.
And to kind of cover this mitigation issue, judges, opposing counsel pointed out, the case law on this largely focuses on a sentencing issue. There is no requirement that the court has to allow additional time or heightened requirements for the defense. Second, if that is genuinely an issue for sentencing, a verdict favorable to the state being reached, potentially sometime in August or September or later, should it be required, the court can always set aside sentencing farther down the line so that the defense would be able to investigate these sentencing issues. There are other alternatives other than pausing the trial. Second, as far as the outstanding evidence from the GBI, that was basically a request for, I'm going to use a term of art here, bench notes, testing procedures, documentation that the testers make during their process. The defense did not ask for that in February or March or April. We don't have a rogue officer here. I do appreciate the hyperbole of defense counsel, but we do not have a rogue officer running wild. We had an officer who tested a firearm in relation to this case, or any case, to be honest. It was not the firearm used in this case. They tested it, they ran it through NIBIN, they did all of the proper testing procedures for that firearm. It's not related to this case. Multiple firearms were tested in relation to this case. None of them are the firearm in question. This is just one of those that the defense was not aware of prior to Friday. It's the exact same thing as all the other firearms we have. There's going to be potentially 2 new leads to chase down, but those things are law enforcement officers. They're going to be here. They may be brought up by the state for cross-examination. If not, the defense can put them up under their own subpoena power in their case in chief. There's nothing to that would require any additional time. Again, the rule here is the 10-day requirement. We are 21 days out as of right now when I stand here in front of the court. We think that there is no necessary foundation legally for the state to continue this case. We think factually there is no requirement that the court continue this case. We think that overall the needs of justice do not demand a continuance in this case. Instead, they demand that this case be reached for trial on August 3rd as set.
Just out of abundance of caution, while I know the rule, some may not. You mentioned 10 days.
Sure.
And that we're 21 days out. I know that.
Yep.
Can you explain that?
I can. So the rules for discovery in Georgia require that all of the information from the state be turned over to defense counsel 10 days prior to trial. For us, we are 21 days out as of today. That counts business days and weekends. So we do have a significant amount of time to give things to them. There may be more things coming, and I can illustrate this with something that was mentioned up in opposing counsel's brief. They were just in receipt of the defendant's calls while she isn't in custody. I'm going to turn those over at 10-day. Again, anything from July 1st through whatever that 10-day is. But I cannot turn over things until I have them. So they're not going to get those until then. As much as I would like to give them the calls that she is making next week, I can't turn over documentation that we don't have. The rule allows us to present evidence as late as 10 days before trial, or more specifically, to make our files available to the defense 10 days before trial. Here we are 21 days out.
I believe you're making reference, you didn't really address this during your presentation, but in the motion that defense presented, there was a reference to a large amount of evidence that was submitted, and there was a certain terabyte amount of lead that was addressed in that particular motion. My understanding is that y'all kind of resolved that, and the bulk of that were these calls that you were just turning over. Is that correct?
That's right, Judge. So to kind of unpack that completely, the 2.5 terabytes of information that defense counsel mentions in their brief, that's the entirety of the case. That is all of the jail calls, all of the phone dumps, everything. 33 gigabytes was turned over a couple of weeks ago to the defense. I had spoken to Mr. Hoover prior to let him know these are the things that are coming. They were not surprised by any of those documents. So everything has been turned over. I think it was just a communication error between opposing counsel and their investigator in regards to what was actually turned over. There was only 33 gigabytes turned over. Again, most of that was jail calls of the defendant, and those can't be turned over until they're actually made. So the totality of what we have was turned over, not even to counsel now, but to prior counsel significantly before trial. The overwhelming majority of that 2.5 terabytes was turned over to Ms. Williams well before the trial that we were going to have in January.
Which would have allowed Ms. Williams to make her announcement ready, which she made in January. Is that correct?
Absolutely, Judge. Absolutely.
Thank you. Anything else to say?
Nothing else, Judge. Thank you.
Brief.
Yeah, I will be brief. So, Your Honor, I do want to start with the back and forth that you and the state had with the 10 days prior to trial.
And again, that really was just to solidify. We have a lot of people in the courtroom. Yes, people hear things. I know their family people that are interested in this case on both sides, and I really was just trying to get the legal requirement out there so they could understand what he meant by that. Because that, as lawyers and my position as judge, we're used to these dates and these time frames, but a lot of people in the audience, they don't know what that means. I just want a little clarification there.
Yes, and to give just a little more clarification, Your Honor, the state is correct that in the state of Georgia, they have 10 days to turn over discovery to the defense. 100% correct. The point that the state kind of glossed over that they didn't mention, that I have to mention, is that the state and Ms. Williams announced ready for trial, and this trial is supposed to go in January. New evidence literally came to existence Friday, yet like literally 3 days ago. The state can't say, well, we have 10 days to turn everything over and everything been turned over when they can't themselves say that they have all the evidence. That's the problem. We are literally getting evidence now that we did not have before. Now, what the state said was, well, this is a gun. It went through the same test that all the other guns did. It wasn't one of them. I don't know that because the officer that didn't write a report for like the last 3 years is now saying that I'm supposed to just take the state's word for it. As a defense attorney, I have to investigate this. At the point where the state makes this bold assertion that, well, this is a gun that we tested like all the other guns and it doesn't exist, we gave it back, I have to do more. I have to see those tests. I have to first, before the test, I have to figure out how he came up with this quote-unquote hunch. I mean, we're in a murder trial, a double homicide, and now rogue officers are bringing in evidence that no one knew before and saying, well, I got it off of a hunch. The state didn't bring that up. The state wants to say that this is just another gun that didn't test as the fire weapon, or the actual weapon is arrest. I can't go with that. The court can't go with that, and a jury can't go with that. As a defense attorney, I have to first start with, what were you doing to where you didn't write the report at the beginning? Who was your commanding officer? Did you follow procedure? The state wants to say, well, we have 10 days to do all. Well, we don't, Your Honor, because now that's a whole new part of my investigation that I have to do once I get those reports. We still don't even have everything from this officer. And again, it's not the DA's office, but we don't have enough from this officer. So when the state said, well, we're still within, 10 days of trial, the state can't stand up here right now and tell you that they know they have all the evidence because it's not possible at this point. They announced ready for trial in January, and we're literally getting new evidence right now. When it comes to GBI and the bench notes, the state wants to say, well, it's just bench notes. It's more than that. Law enforcement did something. They turned over evidence to GBI. I knew there was something wrong with what law enforcement did because I thought it was a chain of custody issue. Come to find out, GBI literally had to restructure everything and go back to law enforcement. So we're not asking for just bench notes. We're asking for what happened at the beginning, what went to GBI, what GBI had to relay back to law enforcement, and what GBI officially did afterwards. So the state's trying to minimize what information that we're still looking for, and that's not the case. We're not talking about an interview. We're talking about more than that. In regards to the DFACS records, Your Honor, we asked for Ms. Patrick's entire DFACS file. The state wants to say, well, they had some of the information, turned it over to Ms. Williams, and Ms. Williams' expert talked about it. Agreed, they had some of it. We're talking about, Ms. Patrick was a juvenile at the time, but we're talking about over a decade's worth of DFACS records that not only the state didn't have, Ms. Williams didn't have, and their expert didn't have. So the state's trying to cherry pick, well, this is just this little bit and this little bit, so it's not that important. Well, it is, because yes, there's a rule for 10 days, and just to back up a little bit, the state said that I've been in this case since February, and I just started after June. 100% correct. I've literally been in trials around the state when I was told that I'm taking over this case. I couldn't take the case in February, a double homicide, and be prepared to argue motions and say, this is what I need at the end of February. The court knows, as an attorney, previous attorney, that's not how murders work. That's not how cases work. I picked up the case in February. I didn't get a new team or new experts to figure out new information. I put my team together once I was told Ms. Patrick's original team was gone, and now this is my case. I have to put a team together. The state will say, well, now I'm asking for new experts, and it's June. That's not how this works. This snowballed into new evidence has been uncovered. More information has told me there's more evidence
Getting outside of brief.
To wrap everything up, Your Honor, there has not been enough time now that there's so much more information. And at the point where the state can't stand up here in front of you and say, Your Honor, we have more than 10 days left, that's the rule, and we can guarantee that all the evidence is turned over. They can't say that because they don't know that for the fact. At this point, we have to have a continuance. The state literally asked or announced ready, not knowing all the evidence in the case. As this taxpayer's attorney, I cannot do that. I will not do that. I will be ineffective. And we're asking for more time because there's more evidence out there that we do not have.
Thank you. I do want to make one slight correction. I believe in January, the state actually announced not, it was Ms. Williams' defense counsel that announced ready. And I believe it was the state that announced not ready. If they both had announced ready in January, I'll try the case in January. I believe it was the state that announced they were not ready. And I believe the sole issue, the only issue that was left in January was a report from the doctor. There was a preliminary report that was provided to defense counsel, which defense counsel then provided to the state. Defense said that they were ready and able to proceed with trial despite not having the full report. They thought they were sufficient, adequate, and prepared to do a full, proper defense of Mr. Patrick with just a preliminary report. The state announced that the judge, we see some issues in the preliminary report, and we believe that we cannot be prepared without the full report, and we need to be offered proper opportunity to have our own expert review the full report. That, as a state, we're entitled to that privilege. It was at that point that I decided to continue the case, and even acknowledge that I believe Ms. Williams, she even needed a full report. And I believe I even placed that on the record at that time, that even though she was willing to go for the preliminary report, I believe that she did need that full report to do an adequate job. I believe that was the only reason for the continuance in January. I've listened to both sides. I should have a ruling within. I need to have a ruling out of the way very quickly so that everyone knows what to anticipate. I do have court the rest of the day today. I have court tomorrow in a separate county. My intention is to have an order to y'all. I'm going to say no later than midday Wednesday, but I really want to have that order out by tomorrow afternoon. So give me till midday Wednesday just in case something happens, but I'm really shooting for tomorrow afternoon to have that order prepared. As I indicated to y'all when y'all came up to this conference, the only thing that can delay that, however I rule, I really do want to make sure that I have the procedural history correct. I've already asked my court reporter to pull the transcript from January, so I make sure that I get that language correct if needed. I need to use that in my order. So that's the only thing that may take me a little bit more time. It's just making sure I have that procedural history accurate to support whichever ruling I can make. I appreciate both of y'all being here today. Appreciate the arguments that have been made. I'll have the order midday Wednesday, if not by tomorrow afternoon.
And Your Honor, just with that said, I apologize. I wasn't here in January, so I didn't know.
Okay.
I need to say, the state asked for a continuance, was granted a continuance in January because there was one sole issue, like the court said, that they need to be prepared for. I am now saying there's not one sole issue that I need to prepare for. There are multiple issues that I need to prepare for, and we're asking for the continuance for that reason. And furthermore, it's still information the state doesn't have either. So the fact that they're still trying to announce ready for trial when they don't have the information that I'm literally saying we still need says a lot. So the state asked for a continuance for one sole issue, it was granted. The defense is asking for a continuance for multiple issues, and it's not something small, it's something major. The state still doesn't have that information.
Mr. Hoover,
We're asking for it.
you've already made your point. And I do want both sides to be aware. I'm giving you a little leeway today. But just random arguments that are made after I've given you time to make your arguments, we'll follow a slightly different decorum court.
Yes, sir. I'm saying.
This is not a time for arguing back and forth in a debate type fashion. It's an order. right? You take a specific order, you presented, state presented, I gave you an opportunity to make rebuttal. And then I announced within the room you made. I think that should suffice. Okay, I appreciate your zealous argument. But I will not let this case get out of hand. I just want to set the tone early. While I appreciate the zealous advocate that you are, and I need you to be that zealous advocate in your life, right? That's how you're supposed to represent your life. The state needs you to do just the same to the state. All parties will stay within the realm of proper court. Okay?
Yes, sir.
I'll have y'all ruling. The ruling should be done by Wednesday at noon, if not by tomorrow. All right, thank you.